Hi, Misha Gill with Speedwell Law. In this video, I'm going to talk about understanding trust funding. Okay, and so first I'll start off with an analogy. A trust is like a bucket of water. It can only pour out assets that make it into the trust. There are various methods for conveying assets that will pass outside of probate that the terms of a trust will not apply to. Those are things that are held jointly and things that are beneficiary designated, pay on death designated, or transfer on death designated when those designations are not made to a trust. Okay? Now, the idea behind trust funding is that you want the terms of the trust to apply to any distributions that have to do with your estate, because that's going to be the most efficient way for your estate to be distributed to your beneficiaries, and also the most protective way, because trusts typically provide additional protections for black swan type scenarios. Okay, so we want to fund our trusts during lifetime or at death. And there's various different ways that you can do that. Now, it's best if the trust is funded by the person making the trust during their lifetime for assets where that is appropriate. And there's a very big category of assets where it's not appropriate to title assets in the name of the trust, namely anything that grows tax deferred. So 401ks, IRAs, you can't put a pension in the trust. Social Security cannot be deposited directly to a trust account. Things like that. Anything that has special tax treatment or that is restricted from going into a trust account, like the Social Security benefits. But the things that aren't in that category, your real property, your bank accounts, life insurance proceeds, stocks, bonds, brokerage accounts, that stuff should be titled in the name of the trust either during life or at death. Okay, and so if you don't do one of those methods that funds the trust during your lifetime or at death, there is a fallback method for funding the trust, and that is the pour over will, which a good estate attorney will always prepare as part of a trust package, and which you should also prepare if you're doing a standalone trust through document assembly software online. And that is a method of last resort for making sure that the trust terms will apply to the distribution. It's inefficient to rely on a pour over will, because then anything that is passing according to the terms of a will is going to pass through probate. Okay, so the number one category of things that should be in your trust during your lifetime: real property. Now, this is a significant efficiency that can be achieved with a trust versus any other means of conveyance, because a piece of real property that passes according to the terms of the trust avoids probate and can be sold or administered efficiently by the trustee. So in general, real property should always be titled in the name of your trust. Seek specific legal advice if there's anything complicated about the form of ownership of that property. Bank accounts, you have a choice whether to add that to the trust during your lifetime or at death with a pay on death designation. There's pros and cons to it. See my other videos for why you would add a bank account to the trust or use a pay on death designation. Life insurance always avoids probate. It's a contractual benefit payable to a person if you die in a way that is covered by the contract. The question just becomes whether you want the asset to be governed by the terms of the trust because you might have minor beneficiaries, or because you have a special needs beneficiary. But in general, sending it through the trust is almost always going to accomplish your wishes and will protect that asset and those people, no matter what comes down the pipe. So even if you were to designate your spouse as the primary beneficiary and the trust as the alternate beneficiary, there's still a situation where that spouse becomes incapacitated during their life and is not an appropriate recipient of those life insurance proceeds because they had a stroke or an aneurysm or a traumatic brain injury. And so it's still better to just designate your trust as the primary beneficiary of a life insurance policy. Okay, and so assets that you do not need to transfer into your trust. I already talked about any bank accounts that are receiving Social Security benefits, and I talked about that in the article. IRAs, 401ks, tax-deferred assets should not be titled in the name of the trust. They can be beneficiary designated to the trust, but should not be owned by a trust. 529 could be owned by a trust, but you don't really need to do that. Cars, at least in Virginia, cars do not have to be owned by the trust. I don't always recommend to my clients that they title the car in the name of the trust unless it's a highly valuable collectible car or a supercar or something like that. Most of the time you're going to have more cars at some point during your life, and many cars can be held in the name of both spouses, both spouses on the title. Unless you are getting up there in age or can see your passing coming in the next, foreseeable future, it's not necessary to title your car in the name of the trust. Virginia specific. Florida there might be different advice. Annuities, typically you would do that with a beneficiary designation, but there's no reason that an annuity couldn't be beneficiary designated to a trust as long as the trust said what happened to those proceeds. But seek specific advice on that. All right, well, hope you enjoyed this video about understanding funding your living trust. If you need any assistance with that and you're in Virginia or Maryland, please reach out. We're always happy to help. Thanks. Misha Gill with Speedwell Law.